William Hubbs Rehnquist was an American lawyer and jurist who served on the Supreme Court of the United States for 33 years, first as an Associate Justice from 1972 to 1986, and then as the 16th Chief Justice of the United States from 1986 until his death in 2005. Considered a conservative, Rehnquist favored a conception of federalism that emphasized the 10th Amendment's reservation of powers to the states. Under this view of federalism, the Supreme Court of the United States, for the first time since the 1930s, struck down an act of Congress as exceeding its power under the Commerce Clause. Rehnquist served as Chief Justice for nearly 19 years, making him the fourth longest-serving Chief Justice after John Marshall, Roger Taney, and Melville Fuller, and the longest-serving Chief Justice who had previously served as an Associate Justice. The last 11 years of Rehnquist's term as Chief Justice marked the second longest tenure of a single unchanging roster of the Supreme Court, exceeded only between February 1812 and September 1823. He is the eighth longest-serving justice in Supreme Court history. Early life. Rehnquist was born William Donald Rehnquist in Milwaukee, Wisconsin, on October 1, 1924. He grew up in the suburb of Shorewood. His father, William Benjamin Rehnquist, was a sales manager at various times for printing equipment, paper, medical supplies and devices. His mother, Marjorie Peck Rehnquist, the daughter of a local hardware store owner who also served as an officer and director of a small insurance company, was a local civic activist, as well as translator and homemaker. Rehnquist changed his middle name to Hubbs, a family name, because a numerologist told his mother he would be successful with a middle initial of H. His paternal grandparents immigrated from Sweden. Rehnquist graduated from Shorewood High School in 1942. He attended Kenyon College in Gambia, Ohio, for 1 quarter in the fall of 1942, before entering the U.S. Army Air Forces. He served from March 1943 to 1946, mostly in assignments in the United States. He was put into a pre-meteorology program and assigned to Denison University until February 1944, when the program was shut down. He served 3 months at Will Rogers Field in Oklahoma City, 3 months in Carlsbad, New Mexico, and then went to Hondo, Texas, for a few months. He was then chosen for another training program, which began at Chanute Field, Illinois, and ended at Fort Monmouth, New Jersey. The program was designed to teach the maintenance and repair of weather instruments. In the summer of 1945, Rehnquist went overseas as a weather observer in North Africa. After the war ended, Rehnquist attended Stanford University with assistance under the provisions of the G.I. Bill. In 1948, he received both a Bachelor of Arts and a Master of Arts degree in political science. In 1950, he attended Harvard University, where he received another Master of Arts, this time in government. He later returned to Stanford, and graduated from the Stanford Law School in the same class as Sandra Day O'Connor, with whom he would later serve on the Supreme Court. They briefly dated at Stanford. Rehnquist graduated first in his class, law clerk at the Supreme Court. Rehnquist went to Washington, D.C., to work as a law clerk for Justice Robert H. Jackson during the court's 1950–1953 term. There, he wrote a memorandum arguing against federal court-ordered school desegregation while the court was considering the landmark case of Brown v. Board of Education, which was later decided in 1954. Rehnquist's 1952 memo, entitled A Random Thought on the Segregation Cases, defended the separate but equal doctrine. In that memo, Rehnquist said, "I realize that it is an unpopular and unhumanitarian position, for which I have been excoriated by liberal colleagues, but I think Plessy v. Ferguson was right and should be reaffirmed. To the argument that a majority may not deprive a minority of its constitutional right, the answer must be made that while this is sound in theory, in the long run it is the majority who will determine what the constitutional rights of the minority are." In both his 1971 Senate confirmation hearing for Associate Justice and his 1986 hearing for Chief Justice, Rehnquist testified that the memorandum reflected the views of Justice Jackson rather than his own views. Rehnquist said, "I believe that the memorandum was prepared by me as a statement of Justice Jackson's tentative views for his own use." Elsie Douglas, longtime secretary and confidant of Justice Jackson, stated during Rehnquist's 1986 hearings that his allegation was a smear of a great man, for whom I served as secretary for many years. Justice Jackson did not ask law clerks to express his views. He expressed his own and they expressed theirs. That is what happened in this instance. However, the papers of Justices Douglas and Frankfurter indicate that Justice Jackson voted for Brown in 1954 only after changing his mind. At his 1986 hearings for Chief Justice, Rehnquist tried to put further distance between himself and the 1952 memo. The bold statement that Plessy was right and should be reaffirmed was not an accurate reflection of my own views at the time. Quote, however, Rehnquist acknowledged defending Plessy in arguments with fellow law clerks. Several commentators have concluded that the memo reflected Rehnquist's own views rather than those of Justice Jackson. A biography on Jackson corroborates this explanation, stating that Jackson instructed his clerks to express their own views, not his. This conclusion is further corroborated by an article published in the Boston College Law Review in 2012, which analyzes a 1955 letter written to Justice Frankfurter that criticized Justice Jackson. In any event, while later serving on the Supreme Court, Rehnquist made no effort to reverse or undermine the Brown decision, and frequently relied upon it as precedent. Rehnquist stated in 1985 that there was a perfectly reasonable argument against Brown v. Borden in favor of Plessy, even though he now saw the court's decision in Brown as correct. In a memorandum to Justice Jackson about Terry v. Adams, which involved the right of blacks to vote in an allegedly private Texas election, Rehnquist wrote, "The Constitution does not prevent the majority from banding together, nor does it attain success in the effort. It is about time the court faced the fact that the white people of the South do not like the colored people. The Constitution restrains them from affecting this dislike through state action, but it most assuredly did not appoint the court as a sociological watchdog to rear up every time private discrimination raises its admittedly ugly head." In another memorandum to Justice Jackson regarding the same case, Rehnquist wrote, "Clerks began screaming as soon as they saw this that now we can show those damn Southerners, etc. I take a dim view of this pathological search for discrimination and as a result I now have something of a mental block against the case." Nevertheless, Rehnquist recommended to Justice Jackson that the Supreme Court should agree to hear the Terry case. Private practice. Rehnquist moved to Phoenix, Arizona, where he was in private law practice from 1953 to 1969. He began his legal work in the firm of Dennis and Kitchell, subsequently the national campaign manager of the Barry M. Goldwater presidential campaign in 1964. During these years, Rehnquist was active in the Republican Party and served as a legal advisor under Kit Shelter Goldwater's campaign. He collaborated with Harry Jaffa on Goldwater's speeches. Many years later, during the 1971 hearing for Associate Justice and later during the 1986 Senate hearings on his Chief Justice nomination, several people came forward to complain about Rehnquist's participation in Operation Eagle Eye, a Republican attempt to discourage minority voters in Arizona elections, when Rehnquist served as a poll watcher in the early 1960s. Rehnquist denied the charges, and Vincent Maggiore, then chairman of the Phoenix Area Democratic Party, said he had never heard any negative reports about Rehnquist's Election Day activities. All of these things, he said, would have come through me, Justice Department. When President Richard Nixon was elected in 1968, Rehnquist returned to work in Washington. He served as Assistant Attorney General of the Office of Legal Counsel from 1969 to 1971. In this role, he served as the chief lawyer to Attorney General John Mitchell. President Nixon mistakenly referred to him as Renchberg in several of the tapes of Oval Office conversations revealed during the Watergate investigations, because he was well placed in the Justice Department. Rehnquist was mentioned for many years as a possibility for the source known as Deep Throat during the Watergate scandal. Once Bob Woodward revealed on May 31, 2005, that W. Mark Feld was Deep Throat, this speculation ended. It was William Rehnquist who determined that Government National Mortgage Association guarantees constituted a full faith and credit promise of the United States. In fall 1971, Nixon received the resignations of two Supreme Court Justices, Hugo Black and John Marshall Harlan II, after compiling an initial list of possible appointees that ran afoul of Chief Justice Burger and the American Bar Association. Nixon considered Rehnquist for one of the slots. Henry Kissinger discussed the possible pick with presidential advisor H. R. Haldeman and asked, "Rehnquist is pretty far right, isn't he?" Haldeman responded, "Oh Christ, he's way to the right of Buchanan," referring to then presidential advisor Patrick Buchanan. Associate Justice Nixon nominated Rehnquist to replace John Marshall Harlan II on the Supreme Court upon Harlan's retirement, and after being confirmed by the Senate by a 68-26 vote on December 10, 1971, Rehnquist took his seat as an Associate Justice on January 7, 1972. There were two vacancies on the court at the time. Nixon nominated Louis Franklin Powell, Jr., to fill the other, left by the retirement of Hugo Black. Black died September 25, 1971, and Harlan died on December 29 of that year. On the Burger Court, Rehnquist promptly established himself as the most conservative of Nixon's appointees, taking a narrow view of the 14th Amendment and a broad view of state power. Rehnquist almost always voted with the prosecution in criminal cases, with business in antitrust cases, with employers in labor cases, and with the government in speech cases. Quote, "Although Rehnquist was often a lone dissenter in cases early on, his views would later often become the majority view of the court." Professor David Shapiro of Harvard Law School suggested that Rehnquist's votes were guided by three basic propositions. Conflicts between an individual and the government should, whenever possible, be resolved against the individual. Conflicts between state and federal authority should, whenever possible, be resolved in favor of the states. Questions of the exercise of federal jurisdiction should, whenever possible, be resolved against such exercise. Federalism. For years, Rehnquist was determined to keep cases involving individual rights in state courts away from federal reach. In 1977's National League of Cities v. usury. Rehnquist's majority opinion invalidated a federal law extending minimum wage and maximum hours provisions to state and local government employees. Rehnquist wrote that this exercise of congressional authority does not comport with the federal system of government embodied in the Constitution. As Chief Justice, Rehnquist presided over what law professor Erwin Chemerinsky has called a Federalist Revolution, during which the court limited federal power in cases such as New York v. United States v. Lopez, Prince v. United States, and United States v. Morrison. Similarly, Cato Institute scholar Roger Pilon has said that the Rehnquist court has revived the doctrine of federalism, only at the edges and in very easy cases. Equal protection, civil rights, and abortion. Rehnquist rejected a broad view of the 14th Amendment. In 1952, while serving as a clerk to Supreme Court Justice Robert Jackson, Rehnquist wrote a memorandum which concludes that Plessy v. Ferguson was right and should be reaffirmed. If the 14th Amendment did not enact Spencer's social statics, it just as surely did not enact Maydal's American Dilemma, by which he meant that the court should not read its own sociological views into the Constitution. Quote, he believed that the 14th Amendment was meant only as a solution to the problems of slavery, and was misapplied when applied towards abortion rights or prisoners' rights. Rehnquist believed that the court had no business reflecting society's changing and expanding values, and argued that this was the domain of the Congress. Rehnquist tried to weave his view of the amendment into his opinion for Fitzpatrick v. Bitzer, but it was rejected by the other justices. Rehnquist later extended what he said he saw as the scope of the amendment, writing in Trimble v. Gordon, except in the area of the law in which the framers obviously meant it to apply classifications based on race or on national origin. Also, during the Burger Court's deliberations over Roe v. Wade, Rehnquist promoted his view that courts' jurisdiction does not apply over abortion. He voted against the expansion of school desegregation plans and the establishment of legalized abortions, dissenting in Roe v. Wade, 410 U.S. 113. Rehnquist expressed his views about the Equal Protection Clause in cases like Trimble v. Gordon. Unfortunately, more than a century of decisions under this clause of the 14th Amendment have produced a syndrome wherein this court seems to regard the Equal Protection Clause as a cat o' nine tails to be kept in the judicial closet as a threat to legislatures which may, in the view of the judiciary, get out of hand and pass arbitrary, illogical, or unreasonable laws, except in the area of the law in which the framers obviously meant it to apply classifications based on race or on national origin. The first cousin of race, the court's decisions can fairly be described as an endless tinkering with legislative judgments, a series of conclusions unsupported by any central guiding principle. Other issues. Rehnquist consistently defended state-sanctioned prayer in public schools. Rehnquist held a restrictive view of criminals' and prisoners' rights, and held the view that capital punishment is constitutionally permissible. He supported the view that the Fourth Amendment permitted a warrantless search incident to a valid arrest. In Nixon v. Administrator of General Services, Rehnquist dissented from a decision upholding the constitutionality of an act that gave a federal agency administrator certain authority over former President Nixon's presidential papers and tape recordings. He dissented solely on the ground that the law was a clear violation of the constitutional principle of separation of powers. During oral argument in Durham v. Missouri. The court faced a challenge to laws and practices that made jury duty voluntary for women in that state. At the end of Ruth Ginsburg's oral presentation, Rehnquist asked her, "You'll not settle for putting Susan B. Anthony on the new dollar, then?" Rehnquist wrote the majority opinion in Diamond v. Dare, 450 U.S. 175, which began a gradual trend toward overturning the ban on software patents in the United States, first established in Parker v. Fluke, 437 U.S. 584. In Sony Corp. of America v. Universal City Studios, Inc., pertaining to video cassette recorders such as the Betamax system. Justice Stevens again wrote an opinion providing a broad fair use doctrine, while Rehnquist joined the dissent, which supported stronger copyrights. Years later, in Eldred v. Ashcroft, 537 U.S. 186, Rehnquist was in the majority favoring the copyright holders, with Justices Stevens and Breyer dissenting in favor of a narrower construction of copyright law. Rehnquist's view of the rational basis test. David Shapiro, professor of law at Harvard University, wrote that while Rehnquist was an associate justice, he disliked even minimal inquiries into legislative objectives except in the areas of race, national origin, and infringement of specific constitutional guarantees. For Rehnquist, the rational basis test, which is an important part of equal protection jurisprudence, was not a standard for weighing the interests of the government against the individual, rather, it was a label to describe a preordained result. Shapiro in 1978 pointed out that Rehnquist had avoided joining rational basis determinations for years, except in one case, Weinberger v. Wiesenfeld. Rehnquist eschewed the court majority's approach to equal protection, writing in dissent in Trimble v. Gordon that the state's distinction should be sustained because it was not mindless and patently irrational. Shapiro pointed out that Rehnquist seemed content to find a sufficient relationship between a challenged classification and perceived governmental interests, no matter how tenuous or speculative that relationship might be. A practical result of Rehnquist's view of rational basis can be seen in Cleveland Board of Education v. Lafleur, wherein the court's majority struck down a school board rule that required every pregnant teacher to take unpaid maternity leave beginning 5 months before the expected birth of her child. Justice Powell wrote an opinion rested on the ground that the school board rule was too overinclusive to survive equal protection analysis. In dissent, Rehnquist attacked Powell's opinion, saying, "If legislative bodies are to be permitted to draw a line anywhere short of the delivery room, I can find no judicial standard of measurement which says the ones drawn here were invalid." Shapiro writes that Rehnquist's opinion implied that there is no constitutionally significant difference between a classification that encompasses virtually no one outside the scope of its purpose, and a classification so overinclusive that the vast majority of those falling within are beyond its intended scope. Rehnquist's dissent in United States Department of Agriculture v. Murray illuminates his view that a classification should pass muster under the rational basis test so long as that classification is not entirely counterproductive with respect to the purposes of the legislation in which it is contained. Shapiro alleges that Rehnquist's stance makes rational basis a virtual nullity. Relations on the court. Rehnquist built warm personal relations with his colleagues, even with ideological opposites. Justice William Brennan, Jr., startled one acquaintance by informing him that Bill Rehnquist is my best friend up here. Rehnquist and Justice William O. Douglas bonded over a shared iconoclasm and love of the West. The Brethren claims that the court's liberals found it hard not to like the good-natured, thoughtful Rehnquist, despite finding his legal philosophy extreme, and that Justice Stewart regarded Rehnquist as excellent and a team player, a part of the group in the center of the court, even though he usually ended up in the conservative bloc. Since Rehnquist's first years on the Supreme Court, other justices criticized what they saw as his willingness to cut corners to reach a conservative result, gloss over inconsistencies of logic or fact, or distinguishing indistinct cases to reach the destination. In Jefferson v. Taney, for example, Douglas and Justice Thurgood Marshall charged that Rehnquist's opinion misrepresented the legislative history of a federal welfare program. Rehnquist did not correct what the Brethren characterizes as an outright misstatement. Publish an opinion that twisted the facts. Rehnquist's misuse of precedents in another case shocked Justice John Paul Stevens. For his part, Rehnquist was often contemptuous of Brennan's opinions, seeing them as bending the facts a law to suit his purposes. Reluctant to compromise, Rehnquist was the most frequent sole dissenter during the Burger years, garnering the nickname the Lone Ranger. He usually voted with Chief Justice Burger, and, recognizing the importance of his relationship with Burger, often went along to get along, joining Burger's majority opinions even when he disagreed with them, and, in important cases, to straighten him out.